right? Okay.
This meeting is being recorded.
Welcome to the Marsh Claims webinar, Claims Excellence, what can enable and how to deliver. I can see that the number of participants are rapidly rising. It's 4:02, maybe in next 60 seconds, we will formally kickstart the webinar. I could hear some background noise from, yeah, so thank you. I'm really excited about this webinar. I see more and more colleagues are joining in, more and more clients are joining in, and we have a very impressive set of speakers who really know their subject on the claims. And I would truly say they are the true experts, because they are the loss adjusters, the leading loss adjusters of our country. Each one of them have huge amount of experience in handling large, complex claims which are real. And all of them come from organizations which command respect in the insurance system. And that's extremely important, particularly in this profession where there are many loss adjusters, but there are loss adjusters who really have a name. And I would say each one of them command a lot of respect with what they bring to the industry. I could see that the number of participants have risen rapidly, and I would not wait any further and kickstart the webinar. Let me once again welcome. This is Sanjay Kedia, Marsh Country Head and CEO for our business. And in terms of the process, I know all of us know how to handle Zoom, so I would not get into that. Only one request. The entire approach of this panel discussion is interactive. This webinar is for you. If you have any questions, any comments, please feel free to share using the Q&A tab, not the chat option. Even if you want to speak, we'll try and get as many people to speak as well. I'm talking about in the participants also, but that would be towards a little later part. But during the entire program, from the very beginning, feel free to raise your questions as often as you like, okay? We will also be having some live polls where your views matter the most. So please do participate and share your views. Next. A quick introduction. I know most clients know these names. They have experienced them, they have dealt with them, but for the sake of process and courtesy, let me take through, not in any particular order. We have Mr. Somil Mehta, a very seasoned, experienced gentleman. He is part of Mehta and Padamsi Insurance Surveyors. Avya Kapoor from Proclaim Insurance Surveyors. Munish Brasher from Puri Crawford and Associates, and Vivek Johar from Protocol Insurance Surveyors. And the entire program will be moderated by Managing Director of Marsh India, Shantanu Saran, who leads our North and also some of the claims and other functions. So with this, let me hand over to Shantanu for an engaging discussions on claims excellence. Shantanu, over to you.
Thank you, Sanjay. Thanks for the introduction and setting up the context. A warm welcome to all our participants and audience and our clients for this webinar on claim excellence, what can enable and how to deliver. While we keep talking about insurance, highlighting the importance of the industry, but the real essence of insurance comes when, a claim gets realized in a seamless way. If you look at the entire claim life cycle as such, the surveyors play an important dominant role in the same. And that's why when we were deliberating on this webinar, who should be the panel speaker, I think the right choice we made is of the industry's best surveyor, sharing their experience and views and insights as well. While from a discussion perspective, we have kept it more generic so that we dwell on issues, which crops up during the claim settlement time as such. And that's what we are going to discuss all across. So let me, without wasting further time, get to the questions to our esteemed panel speakers. Vivek sir, let me start with you. Thank you everyone for joining. Look forward for an enriching session, with you. Now, in your experience and, whenever we've interacted, I think one area you've always highlighted that Shantanu, it's the initial days of the claim which defines how the claim is going to be settled. And sir, you've done so many lost site visits. From your experience, what are the areas of challenge you see where an insured miss out of ignorance, which kind of amplify the complexity in the claim? And if you can give us some examples also, and how to rectify those mistakes in order to maximize on the claim. Yes, sir.
Good afternoon, everybody, and thanks, Marsh, for having this a very webinar coming out into this, and hope we are able to audience and Marsh is looking for. As far as Shantanu, the question is yes. The first most point agenda, what we as a surveyors we always have been doing is yes, we have to go with a positive frame of mind, and in any large loss, what happens is there's a large loss, whether it is a fire or a major breakdown or something happening. This is a calamity for the client, and he is in such a distress that if you expect on day one, the things are to be put in place, or whatever you require, you get it. No, it should not happen that way. So there could be some kind of things which we feel that client can put in as a one kind of resource, who at the time he has priorities to bring his business back into action. For that he has to do it all the jobs what are required to, but at the same time he can put in some kind of a resource on to create some kind of put evidence into the place, that all the evidence which is required by the surveyor at a later date, they should be available to them. That may come after a few days, but yes, first few days evidence is very important. And the trust factor from day one, if the trust factor between the insured, the surveyors and the brokers is made, and that is at that particular point of time, as far as the streamline settlement process settlement of the claim is concerned. I give you a very live example is that we recently had a very major explosion in which few persons were very severely injured also, and one person later succumbed to the injuries also, while the client was working with the authorities, because there was loss of life also, there were injuries also, there was a third party liabilities from outside the thing also they were happening. That client was done, he was, and at the same time his plant was shut down, and he was ordered by the government to close down the plant. So his entire business is shattered, his entire business is shut down, and he has to he's also looking for the, because police also looking for them, because there might be some kind of negligence. So as an insurance might be a last priority for him at that particular point of time, but he put the resources on time, whatever that resource could help out. This is how the things are going on. We were kept in the loop. That loop is important, so that the broker surveyors were there as part of his team itself, and they were regularly updating, so that things are on live. We were on live thing as far as this thing is concerned. So that is what is important.
Thank you, sir. So more of summarizing on this, that, when an incident happens, I think taking the insurer and the surveyors hand on with all the process which they are doing, while the priority is to get back on the business, but at the same time, keeping more of an open and transparent communication with the surveyor will be a much better approach on a seamless claim settlement. Appreciate, sir. Thanks to you for your views. Moving on to Soumya, sir. You've seen the sheer evolution of the industry. I mean, the kind of work experience you have in this industry, sir. We've seen, the aggregation of loss is one of a contentious issue in any claim as such. What are your advice on to the insureds on how to identify and arrest those aggravation of loss which impacts them at a later stage at the time of claim settlement?
Thank you, Shantanu. You make me sound like a museum piece. I hope I'm not. I take on what Vivek said. Basically, we surveyors tend to go for a survey with empathy. We know somebody has suffered. We are not policemen. We want to go and assist as much as we can in the claim process, which is definitely not easy, even for the simplest claim, because we require a lot of information. How to prevent aggravation? I think take surveyors and insurers into confidence. We are not on opposite sides. We are on the same side. We want a fair settlement. I can give you an example of a claim I had a few years ago in a paint factory, I'm not giving names, where the damage by fire was so severe, and it was reported adversely in the press. The MD of the company called me and said that, listen, we are going to give out a statement in the press that our business is not affected, whereas actually it has been affected significantly. Would we have a problem in the claim? I think just this meeting made a lot of difference, because one could take the insurers into confidence also and say that this is happening for business continuity. It is not for the sake of an insurance claim. So a statement made like that is more public relations and not insurance related. What happens at times, and this is something I would just caution a few people, invariably, if there are injuries, the factory inspector comes and he has to find faults normally with the way things are conducted, and show cause notices are sent off, and people are told, the penalty is pretty low, so why don't you just agree and close it? Now, I think that's a little dangerous, because often in the show cause notice, what is being alleged is gross negligence. That can be interpreted differently by an insurer who is so inclined. I know most of them are not, but it leaves it open. Aggravation, as whatever plans you have for reconstruction, getting back to business, keep the surveyor in the loop. I think that helps the most. I think I'll stop till further questions come in.
No, sir, thank you. And I see a common view from you and Vivek, sir. Keep the surveyor in loop. Keep the dialogue more transparent and open, so that there is no shock effect at the time of claim settlement as such. Munish, coming to you, if you look at from a documentation side, and that's also pain area which goes through there. A lot of time, there is a vicious circle of a documentation happening as such. And insured perspective is we are again getting the same set of documents. But if we go by the PPI guidelines, there are a lot of documents which are available in the public domain, which need not be called for by the insurer or the surveyor as such. What are these documents? What are the challenges as a surveyor you feel not getting it directly, but to get it from the insured? And what preparation or advice you to the insured in terms of how they should be prepared for?
Thank you, Marsh, for inviting us on this Before I answer this question, I think Saumil sir and Vivek articulated very nicely the first two questions. I just want to add one more thing in that. Lot of time, the problems are on the side of the policy side. So a lot of time when we go for the surveys, we observe that the problems in the policy, because either the address is not right, or there are certain warranties which the client has not opted for. So I think this is one more thing which I would like to advise to the audience, that whenever you receive any policy, please go through it, and if there is any problem in that, just inform the insurers so that they pass the endorsement and rectify it, so that there should not be any problem at the time of claim. And this is very a common problem we have observed in number of claims. So I think now coming back to your question, it is true that some of the documents, some basic documents are available at the public domain MCS sites, but these documents are generally for the private and public limited. So if you talk about other proprietorship, partnership, these documents are generally not there. So we can easily get the documents like certificate of incorporation, who are the directors, and change in directors if any, or the annual returns and all that. But the problem, a lot of time what we see is these are not updated by the corporates, or even if we take these copies from these public domain, these are not in legible form.
Meeting is being recorded.
So this is what the challenge what we face. And apart from that, a lot of times the insurers ask for the certified copies from the auditors. So these are the few, I think, but these are very basic documents. Yes, one can obtain these documents from the public domain.
So, just to summarize your point, that while the endeavor is there to get those publicly available documents, but if in case there is a gap as per the requirement, you do reach out to the insured directly for the additional set of information and documents. Fair point. Moving on to Saumil sir again, you have diverse experience managing, manage some complex, large claims, sir. And business interruption is always an area of learning each claim as such for us, for you, for everyone. In BI, we see the market prevalence is to arrive at estimated value for a potential loss of profit claim as such. What is your advice and guidance to insureds here, participants here, in terms of what are the methodology they should use to avoid any aftershocks or gaps later on at the time of claim settlement?
Basically, one would get back to the first answer that I gave, the one as to what ought to be the way forward. Now, one fact which is clearly evident is that nobody knows the business as well as the insured does.
Yeah.
The surveyor may know insurance a wee bit better, not necessarily, but it would be very good to have a dialogue as to what is the impact of the accident on the business and what sort of way forward should it be taken. Collect data on production, turnover, get outsourcing done, get trading done. Ultimately, all of us believe that the insured wants to mitigate the loss as much as he can, irrespective of whether there is a BI policy or not. Again, as I said, the dialogue with the surveyor and the insurer would mitigate problems which could crop up later. What tends to happen is in a lighter vein, we are often, the insured's neighbor will call the surveyor as the hitman of the insurer. It is not so. He is not an opponent. Please believe that and share what's happening. It would make the whole process cleaner, faster, simpler.
Thank you, sir. Abhay, I would like to add on the BI, value. What are advisory from your side in terms of, how to avoid any aftershock at the time of claim?
Thank you.
What are things,
I think,
insured need to be just mindful of when they arrive at the estimated BI value?
so primarily, as Mr. Mehta said, once you keep the adjuster involved, once you keep us, aware of what's happening, the primary aspect that we would like you to ensure is you make a schedule or a bar chart or a activity list that you intend to incorporate and implement in the next, let's say, 3 months, 6 months, 8 months, depending on the indemnity period. Believe me, that is one activity that might take probably 2 to 3 days, but it is the most vital activity eventually when it comes to establishment of your BI. Because the trends, the numbers, the GP will always come from the historical evidence. It's something that not many can change, not many would be able to change. What you can assist with is mitigation. As Mr. Mehta said, what you can assist with is understanding with the adjuster where you could mitigate, where you could manage trading, where you could manage other aspects. And that's when you'll find that your claim is actually being generated in a cohesive manner alongside the adjuster, and thus there will be very minuscule deviations, if any, at the end of the day. Because if the adjuster has been involved on day one and manages the process of reinstatement with you, there are very little points of disagreement at a later stage. So again, I think this theme of this event would thus be keep us involved, don't consider us as opponents, have faith in us, have trust in us, and there will be ability to deliver a better eventually.
Oh, sounds good, Abhay. Thanks for all the insights. Coming back to you, Vivek, sir, one of our, other contentious issue we see is the treatment of taxes, GST, duties to arrive at value at risk. What are your advisory to the insured here in terms of what are things they should be mindful of so that they get a value which doesn't kind of impact them, at the time of claim settlement?
See, as far as GST or the taxes route, right now we are talking of GST all across. So GST impacts the claim, or it has a different meanings in different ways in two different forms in the claim. One is towards the stocks and one is towards the assets, fixed assets, or the capital goods, we can say that. So at the time of stocks claim, the client might have to do the reversal of the GST and GST forms as a cost to them. While declaring the sum insured, they might not have taken the cost of this GST, because that is not cost to them, because they always book the cost as only the related cost, and GST reversal is available to them, so they don't declare it. But at the time of claim, it is a different thing, because that is paid, that has to be paid to them, paid by them. So in that case, GST, the intent of the insured was not to pay the GST at the premium for the GST at that particular point of time. So they might have to have the hit of that. So my advice here would be, yes, the GST has to be insured as GST cost has to be taken in also into the account as far as the cost is concerned for the stocks. For building and plant and machinery, or the fixed assets we call it, GST again is reversible. For building, it might not be building as it is not. For the plant and machinery or the fixed assets, there is a thing that yes, GST, they get a credit for the GST. They declare the sum insured. Normally, the sum insured is declared on what has been the cost to the project or the fixed asset register they have. Based on that, they declare it, and GST is never a component of that particular cost. Again, GST per se is not insured. At the time of claim, if it happens within a particular time period when the GST has not been fully, the time period has not passed, like 5 years is for the thing. So they might have to do a reversal of that portion of the GST. So it is a very dynamic costing for GST that particular point of time. Again, their intent and that particular point of time was not to take the GST, not to insure for the GST. There again, they have to take that particular portion of the hit. So my request here is along with the brokers is, if a particular point where GST component can be insured on some kind of dynamic way, that can be taken up with the insurers, and that should be forming part. Otherwise, GST for stocks or this thing is always a dispute in this.
Thanks, Vivek sir. Somin sir, would you like to add in, on Vivek sir's point?
Vivek has summed it up pretty well. What I would add here is that I don't think it's the intent not to include GST, but till there is a claim, the thought process is such that you just ignore it. You see the values being sent, say, stocks to the bank or in the books, they are all without GST. And the sum insured is taken in that manner. I don't think it's the intent. Now, whether it's included or not, the policy would require the value to be included as far as the liability is concerned. That would include GST in that. So not including it is dangerous. Vivek raised a good point. If there's some way to devise a cover for additional, there used to be a cover for additional custom duty at one time. If something like that, I mean, you people would know far better than any of us how such a cover can be devised. I'm just leaving it as a thought for you.
Yeah, it might be some kind of add-on to the.
Yes.
Sure, sir. Appreciate your points. Thank you for summing it up. Avya, coming back to you, while you've handled a diverse claim, but your specialty again is on, these special lines of insurance, recall, cyber. We are seeing increased government scrutiny, regulations all across. Coming to the product recall claims, which are geographies you are seeing highest severity of these claims? Which industry segments you see again a high severity? And what are the claim triggers which are leading to these recalls?
So Shantanu, it's quite a trend now, and I've often said this to other people in other forums. When product liability and product recall started, it was more a particular document thrown into the face of the insured in India because they were supplying product to the US. And the customer would say, well, if you don't have a product liability, I won't take your product. So the insured in India would get a product liability policy. And back in the day in 2005, 6, 7, 8, we used to see a lot of triggers and a lot of claims and a lot of notifications from the US market. But I think that trend has sincerely and consistently shifted, wherein you see a lot more notifications emanating out of the European market today. I think particularly because a lot more supply is directed from India towards the European market today. That's probably one of the reasons. But the other reason would also be that the European market is consistently more litigious today. I mean, like a German geography would be consistently more litigious today than probably a US, especially the southern part of US or the Texas bits and so on and so forth. Also within the US, remember that they have these state-driven policies. So you have to have a state-driven entity to be able to claim. So that being the trend, you find a lot more European-related notifications coming out today than US-driven notifications. And secondly, to your point, we see a lot more auto and a lot more pharma notifications coming out in today's day and age. I think this has been also a very consistent trend where the supplies within India increase towards your customers overseas in pharma and auto, and that's where you find most of your claims emanating out of. And lastly, you asked where are the trigger points? On product liability, product defects. Auto, largely easier because a product defect can be identified physically. Pharma, a lot more difficult because efficacy is something that is not paid under the policy. But beyond efficacy, if there is a product defect, that is something that forms a subject matter of indemnity. Having said that, we must not confuse product defect with contamination or commingling. That's something that insureds in the pharma industry sort of confuse themselves with a lot. And that's something that is bifurcated and truly defined under the policy. So, I mean, I believe I've answered all of what you asked.
Thanks, Avya. This was truly insightful. Continuing with the same, subject on recall, and I'm going back to you, Manish. It is important to have a recall plan. In terms of how to respond, adequately to a recall claim. What are the mitigation measures you advise to the insureds in terms of reducing the recall claim or recall incidents or reducing the overall claim amount?
I think reducing the recall claims is not possible because recall has happened because of the product defect. But yes, a better strategy can be made to deal with that recall. Generally the recall depends on the territory, what kind of defect the product has, whether it is repairable or that need to be replaced. Sometimes the cost of the product is much higher than recalling that, back to the plant. So all these it can be decided based on the actual position of that. But definitely, if the corporates have a team to with a broad guidelines, what action they will take at the time of any such situation, that will be definitely very helpful.
We are coming back to you in terms of mitigating the recall incidents. What are your advisory to clients in terms of the risk mitigation aspect?
Recall, I would suggest a client looks at a recall in a very proactive manner, yes, but also in a very pragmatic manner. You need to understand whether recall is critical or non-critical. Depending on that, you implement the right steps to be able to safeguard your expenses and also to be able to safeguard the interests of the underwriters. So as Monish put it, you can't expect the underwriters to pay you, let's say, 100 rupees for recall when the cost of the product itself for resending it would be, let's say, in the vicinity of 1 rupee, or disposing it would be in the vicinity of 1 rupee. So that happens in a pharma product. Insured will tell you that we want to recall because the particular territory does not allow us to extract it from customs, right? Appreciate that, understand that, not an issue. However, if there is a cost involved wide which you can extract and dispose, which is lower than the cost of recall, why wouldn't you do that? And that is where I think the insured needs to liaise a little better with the broker and as well as us to be able to assimilate what are the costs involved, how can we mitigate the exposure, and the manner in which we can address these costs under the policy.
Yes, thanks again, Avya. Moving on to the other topic, which is, of course, the burning issue all across, is on cyber claims. Yesterday itself, there was a news that, till June itself, India alone has, almost 670,000 attacks. We are talking about 125 attacks per day basis as such. That's the frequency of attacks in our country itself. We are just starting with a basic question here. With respect to cyber attack, what's your guidance on do's and don'ts, for any client or any insured as such?
I think we will all agree that the basic do's and don'ts evolve around information. You need to ensure that you abide by your policy document wherein it is expected out of an insured to inform a cyber breach at the earliest opportunity. As many of us adjusters know and have already voiced our opinion on this, that the first week of a cyber incident is probably the most critical, because that's when you assimilate whether the breach is active, non-active, and what is the extent of the breach, or whether there is a data exfiltration or not. Now, these are issues that most insureds are aware of. But my view is that whilst most insureds are aware of, the lever of implementing these safeguards are with the insurance team, which may not have the ability to assist with or to navigate the IT team. And that's where cohesive reviews must be done to be able to ensure that everybody is aligned, everybody is on the same page, everybody is on the same table, making sure that the cyber breach is addressed in the most pragmatic and the most proactive manner.
Continuing on same subject, in case of a ransomware attack, and this question is to Vivek sir, what all strategies we can advise to ensure in terms of how to engage with the threat actors, and how do they respond to the dilemma whether to pay or not, when it comes to payment of ransomware, ransom amounts as such. So what is your experience and guidance on this, sir? You're on mute, sir.
We recently were working on certain incidents of ransomware, because that is again on the increase. Yes, ransom is not sort of a legalized as far as the RBI goes, that yes, it is not paying for a ransom is not a legal thing, and same. But at the same time, like Avya said, first 1 week is critical. I would say yes, it is. For the first, I would say few hours, or 8 hours or 24 hours or 48, depending on the business, they are critical for any kind of attack, ransom attack where we have. So we need to have the critical data in place, whether the data has, that data goes into public domain, what could be the liabilities or what could be the losses to us, to the client. That has to be seen. And at times what happens is that underwriters might not know of this. Underwriters come to know only after 1 week of the incident. They are briefed after everything is over. So ransom in that case does, if the data is very critical in nature and the client's business is at stake, they might have to pay ransom, and they have to pay, I would say, ransom at that time. And as loss adjusters, we then need to understand the entire gambit of how the cyber experts come into play. We need to have the cyber experts who come into play and work on the how this attack has happened and what circumstances the ransom was paid at if at all it was paid. We need to work on all these issues at different times.
Thanks, sir. Coming back to you, Manish, like to add in terms of a ransomware attack, what's your guidance?
I was reading the global market condition report 2021, and the cyber related business interruption was the coverage that the buyers are most interested in, and the cyber extortion and ransom is the second in that list. Ultimately, it is the decision of the insured whether to pay or not to pay the ransom. But they need to demonstrate the logic why they want to pay the ransom. And to be very honest, they need to do a risk analysis for that. A lot of risks are involved. For example, who are threat actors? What is the cost of that ransom? What is the cost of that data of the business interruption? Is there any possibility of the re-extortion? Or let's say, even if you pay that ransom, there is a possibility of the cyber attack. So one needs to have a proper risk assessment prior to deciding on that. And one thing, even if they want to determine that they should engage with the threat actors, it's my sincere advice that please go through the professional negotiators. because it requires a lot of compliances. For example, it's basically a threat actor profile is required for that. Who are they? Whether is there any OFAC sanction or EU sanction there, or whether that money is not, they are not using for the purpose of terrorist risk, terrorist financing or so. So all these things need to check prior to deciding whether they want to pay the ransom or not. It is they need to demonstrate that to the insurers that whatever their decision they had taken it is as a prudent uninsured. It is nothing to do with the policy, and definitely it has an actually it has the corporates decide on the ransom because it impacts the business interruption.
Yeah, so point taken. Of course, cyber is still an evolving issue. I think the policy form is evolving, and while it does come with a ecosystem around where negotiators, legal experts, PR, and forensics are inbuilt, but yes, that's an area which is still an unknown territory which is expanding. Coming back to Avya, and this is the last question. I can see a lot of questions coming from audience related to claims. Before we get into that, last question on the panel is, when we talk about from a cyber risk as such, there are a lot of exposure on the other risk. And when I talk about the other risk is including professional indemnity, even DNO. What has been your experience and what is your guidance in terms of mitigation measures from an insured side?
So mitigation, that's a tough one, Shantanu. Mitigation for a liability that is presented on you is something that is probably unavailable, because all you can do is act in a prudent manner. But from a larger perspective, you are absolutely right. A cyber event can invoke today and is already invoking in various forms the DNO, the PI of other entities. I mean, to give you an example, I'm not taking any names, but let us say a large payment gateway or an information technology firm that houses data is the victim of a breach. Now, that would not be a large impact to them yet, other than what they have to do as mitigation of exposure, exfiltration, so on and so forth. What will follow is a breach of other entities that they service eventually. And what will also follow is the capability of those other entities to lodge claims against the primary breached entity for mismanagement, for negligence, or for providing software that was not appropriately secure, and so on and so forth. If the entity is listed, well, there you have it. You have a DNO right there. If the entity isn't listed, you still have the capability of other shareholders coming against you saying, well, you ought to have done the security bits properly. So the exposures in the liability domain cannot be capped at one, because an exposure, a breach, can lead to many others eventually. And as I've already said again in other forums, do remember that we are already seeing breaches of 2017 culminate into claims of today, wherein those entities that were breached are being claimed from in terms of recovery today. So you've got a very large ecosystem that is becoming active on being able to recover and subrogate. So that's something that we all need to be aware of, because you're not just settling a claim today, you're settling a claim with the intent of a long entailed exposure that may exist for the future.
Thanks, Avya, for summing it up. Let me just take on the questions, which is already there in the chat box. We have a question from Mr. Amol Patil. And his question is, after survey and finalizing loss assessment, the concerned surveyor released survey report to the concerned insurance company. Can it be possible to share surveyor report to the insured? If so, it will be very useful for analyzing things. So largely the question is, the can the survey report be released to the insured? Anyone can answer. Somin sir, you want to go?
The IRDA regulation says, the one for policyholders protection or protection of policyholders' interests, says that if a claimant asks for a report, my understanding is that the insurer and/or surveyor are obliged to give it, the copy of the survey report.
In fact, sir, maybe you can take on this question because the next question is on similar lines. Any idea when the survey fee and survey appointment will happen from client side rather than insurer side?
I wish that would happen, considering the delays that we have in getting our payment from the insurance companies. It would be a lot faster.
But yes, as per the, Abhay, go ahead.
So as per the regulation today, the insured is well within their right to appoint a loss adjuster as an independent surveyor to the matter in question, whether or not a insurance company has appointed one. So this, as an insured, please recognize your rights. Your rights include the capability of appointing a loss adjuster as an independent surveyor and loss assessor on your own directly.
So we have one question from Mr. Ganesan. Should a claim be denied merely because the charge sheet is filed for violation of Factories Act? I'll just repeat the question. Should a claim be denied merely because the charge sheet is filed for violation of Factories Act? Somin sir, would you like to take it, or Vivek sir?
Yeah, my view is no. My view is no. Unless it shows that there is gross negligence, deliberate negligence, that would be another issue. But violation of not only factory acts, you'll find plenty of violation of plenty of acts. I don't think it is the job of the insurer or the surveyor to ensure that every act is being followed.
Okay. We have a question from, yes. Yes,
I would endorse with what Soumil Bhai has confirmed just now, because while underwriting also, and at the same time, if the insured is doing his business in the right manner and whatever is required of him as the policy says, so there's no way we could deny the underwriter should not be denying the liability out of that.
Thank you, sir. So next question is from Mr. Pradeep. Is it possible to include GST as a part of the insurance coverage for stocks, where I have a separate line saying GST on stocks and the insurance companies agrees for the same? Let me repeat the question. Is it possible to include GST as a part of insurance coverage for stocks, where I have a separate line saying GST on stocks and the insurance company agrees for the same?
This is probably what was discussed, that yes, this can be done. The brokers, the underwriters have to proactively work on that, and this can be made part of the coverage.
Okay. So next question is from Mr. Tarun Kumar. Sometimes policy clauses are open for various interpretation, including non-coverage of an incident. However, insured take all possible steps to minimize the extent of loss. What stand survey takes in such cases? I'll just repeat the question.
It's a little unclear as to what is meant by non-coverage of incident.
First line is not clear.
Sometimes policy clauses are open for various interpretation, including non-coverage of an incident. However, insured take full possible steps to minimize the extent of loss. What stand a surveyor takes in such cases?
So, Shantanu, just to sort of respond to this, as both of the senior surveyors have said, it's a little unclear. But as a response, if policy does not provide coverage for whatever reason, unclear, gray, whatever other reasons, if policy does not provide coverage, then any mitigation or expenses incurred for mitigation are to the wallet of the insured. The policy will not indemnify such expenses.
Thanks, Surveyor. Next question is from Mr. Setul Shah. Under the fidelity policy, and maybe Munish will like to take this. Under the fidelity policy, the indemnification of a particular employees made a dishonest act is compulsory for settlement of claim. That's a quick question. If in the final investigation report by police, the employee is not identified, but police confirms that it must have been done by an employee, will the liability in FG policy trigger?
It's in the charge sheet. It has been.
If in the FIR by police, the employee is not identified, but police confirms that it must have been done by an employee, will the liability in FG policy trigger?
I think ultimately holding someone responsible is need to be from the authorities, and police is one of them. If the police is saying that if it is not in FIR, probably they can take a status report sort of thing from them. And if the police confirms that the employee is involved in that, the liability is there. But there should be a confirmation from the police.
Shantanu, may I add to this? I think the fidelity policy is a precursor to the modern day crime policy. And it would be recommended that an insured review their ability to obtain a crime policy wherein the definition of employee also includes any unidentified employee as part of coverage. So that thus will eliminate the the argument that we could not identify the employee, but an employee would have been involved.
Thanks, Surveyor. The next question is from Subramaniam Gorthi. Would it be possible to enlighten us on these 2 points? Insurance bond, refer new guidelines issued by IRDA, which are effective from 1st April. When will be the product available? And insurance over the frustration of contract by counterparty. Anyone who can take it while, it's more of a surety bond related question, but maybe we can pass on.
The surety bonds, Shantanu, are still in the sandbox, as I understand. Some of them are going to be moved forward in the next month or so. But that's, I think, I think it's a very proactive step from the regulator to manage that. What comes out eventually, well, I think we'll all have to see, we'll all have to review, we'll all have to figure out. What I've seen in the past is a simplified version of the Lloyd's form, which is going to allow surety to be implemented within India for liquidated or for surety bond claims. What was the second question? I'm sorry.
Insurance over the frustration of contract, more of contract frustration cover.
So again, contract frustration within insurance, it is applicable, although there are no case precedences available within India. Globally, there are many case precedences available for frustration of contract and also for hindrance of contract. Within India, unfortunately, there are none, but the Indian regime is moving fiercely towards arbitration, which allows for frustration to be a lot less today. And with the new acts coming in or the new wordings of the acts coming in, you'll find that it's not just when liability is assumed, you can invoke arbitration even when liability is not assumed eventually, but not yet.
Thanks, Avya. Maybe you can take on the next question from Mr. Subhash Dikshit. In a ransomware claim, does the surveyor has any role for negotiation with the attacker, or it has to be performed only by insured or his representative?
So as Monish put it very aptly when he spoke, in a ransomware situation, we would recommend that an appropriate agency from the ecosystem that is approved is appointed on the matter to be able to ensure that if a ransom ought to be paid out, then it is paid out in the legitimate manner in compliance with the RBI regulation. Again, the caveat being, why would a ransom be required to be paid out today? Because I personally, I've been doing cyber since 2012 in the global market. 2014 is when I shifted cyber focus to Indian market. And believe me, between 12 and 14, we may have paid out cyber ransoms, but after 14, 15, We have not had situations where we needed to pay out ransom because you've got capability of backups, you've got capability of mitigation, you've got capability of isolation. So why would you pay? And do remember, paying a ransom doesn't necessarily mean that you're safe today, or your data is safe. The data remains with the attacker. They can still misuse it eventually. So paying a ransom means nothing.
And to be very honest, it's not very easy to see that because it requires a lot of compliances. The insured may come into a problem if they are given a ransom without involving the professionals in that, because it is very important for them to check the threat file.
Thanks, Manish. Maybe Somil sir, this question to you. Can government grants received for the assets will be reduced from the cost value by insurers in case of loss?
Sorry, could you repeat that, Shantanu?
So this is a question from Kutubuddin Hussain. Can government grants received for the assets will be reduced from the cost value by insurers in case of a loss? They're talking about government grants which is received for the assets. Will that be reduced in a total cost value by insurers in case of a loss?
You're talking not of fixing the sum insured, but from the claim point of view.
Yes.
That's right.
The claim is under the policy. The policy says exactly what should be paid. It doesn't say how it should be paid. Ideally, yes, the insurer should be getting back and saying that you've got X amount of money from either the supplier or the government or wherever, or maybe they can look at subrogation if they've got the money from the supplier. I don't think, to sum it up, I don't think it reduces the liability under the policy at all.
So as long as underwriter has underwritten it, they will settle it to the fullest, at the time of claim.
They
Next
should,
question
yes.
is on a marine policy from Mr. Paras Kumar Bhanwadia. Please share your interpretation for institute replacement clause. Does it convert marine policy on a reinstatement basis?
Anybody on marine?
So my marine is a little dusty, but I will attempt this any which ways because being a marine engineer by qualification, it might assist with understanding of the ICCA. It does not entirely commit to you as a reinstatement value policy because do remember marine cargo is an agreed value policy. So it basically suggests that you've got the ability to indemnify yourself for the agreed value plus 10% of if it's CIF plus 10% or so on and so forth, the agreed value as per the policy under the reinstatement clause, institute reinstatement clause.
The next question is from Mr. Hardik Shah. While considering the sum insured of inventory, cost of value of inward transport need to be considered. Can I claim that along with loss of inventory?
Yes, I would
Answer,
say
yes.
yes.
So basically what we are talking about, what is the cost of that product at that particular stage. So if there is any inward cost, yes, they can claim.
Next question is from Mr. Amit Agarwal. The business at the global level has evolved since time, and this evolvement also needs to be reflected in the wordings coverage under the policy. When do we see it happening across sectors? So yes, I think our regulator has just talked about the use and file. Mostly, we'll see development over there. Next question is from Mr. Anil Kunjir. If the sum insured already includes GST amount, can insured claim GST even though GST credit received?
No, I would say, see, what he has to is that if he has already, sum insured can be declared anyways, but if he's getting the GST reversal and whenever he's reinstating the loss, again, he's getting the GST reversal and is not recrediting it back to the GST. So only the loss suffered by him has to be paid.
And second is, it's what we are talking about. Sum insured is a value. It doesn't talk about, what we say is we have included GST in that, but it's nowhere written in the value. Sum insured is just a value. So rightly said, if these are indemnity-based policy. If he has taken the input tax credit, then GST is not. He's not entitled for GST.
Thanks, Manish. Next question is from Mr. Sanjay Shah. Under the storage cum erection policy, due to high inflation, if contractor increase policy sum insured amount towards some supply material, i.e. without amendment of contract value by principal, at the time of claim settlement, will the surveyor insurance company will consider rate as per contract or as per increased rate value by the contract? Should I repeat the question?
No, we've got it. See, in any case, the cost which has to be he has insured, the client has insured the contract, and contract wording, whatever has been made part of the insurance is there. But in case he has the escalation clause with that, so that escalation can be taken to whatever the extent that can be there in the policy, and that can be taken into account. As far as increasing the sum insured midway, yes, that can be if the cost of the supply material to the contract is more than what the contract was, or it had procured the contract is more, then also with the increase of sum insured, it can be taken into account. Depending on the policies, we have to look into it.
Then we have a question from Mr. Sridhar Subramaniam. If the root cause of a fire accident is proved to be negligence on the part of management with respect to adherence to preventive maintenance schedules as recommended by Oems, can the claim be rejected?
If it's part of the policy, yes. If it's not part of the policy, no.
Thank you. We have a question from Mr. Deepak Yadav. My question is for all the panel members. Being a surveyor and an investigator, how a surveyor verify the turnover under sales turnover policy in case of export sales? Is it based on initial custom invoice, which is issued for custom formalities purpose and booking of containers for export, or on the basis of final export invoice registered in the system, which is issued after receipt of BL basis on which balance sheet financial audit has been done?
I would say
Final one.
Yeah.
if it is a sales turnover policy, then whatever is coming in the books, that will form part of the basis of assessment also, and which is the export invoice, the final export invoice, which is going as part of his proper invoice, which is adding to his turnover.
Sure. So, Niladri, there are a lot of people who have raised hands, and we can just allow them.
Yeah, I'll just.
Yeah.
Yeah, Mr. Krishnamurthy, you are unmuted. If you would like to ask any question, you can go ahead, unmute yourself, and you can talk to us.
Good evening, Mr. Krishnamurthy. May I have your question, please, to the panel?
Mr. Pramod Jain, you can also ask your question. I have unmuted your line.
Just now we having discussion over GST issue. Definitely GST, if in normal circumstances, usually as a separate sum insured, it is never been available. So far as policy says, if sum insured is adequate, then how GST is going to treat it? If sum insured is still inadequate, even after incorporation of the GST.
Then GST is payable. So if the sum insured, if you talk about the stocks, and if the value at risk inclusive of GST is adequate, a GST is payable subject to submission of the evidence that you have reversed the input credit of GST in your
Yes.
Yes, Mr. Krishnamurthy. Anyone else like to go for questions with the panel? I can see Saryu raising her hand. Saryu, you can unmute and
Yeah,
ask
we have
questions.
already unmuted her line, his line.
Yes, Saryu.
Hello.
Yeah, please go ahead.
Hi. Thanks, Shantanu. So my question to the entire panel members is that mostly with respect to the cash fidelity policies, etc. Normally, what the insurance companies PSUs do is that when the FIR is lodged, a part payment happens. But especially on the fidelity, they wait for the final investigation report or the closure report to be submitted. Now we've seen police taking 7-10 years for that, with the justification that the culprit has been caught. Now, whether they've recovered cash or they haven't recovered cash, etc., is something which is always ambiguous. So insurance companies usually hold the full payment, stating that they will wait for the closure report. Is there any timeline post which, in case the police does not close the claim, we can request the insurance company to conclude the losses, or it's an ongoing thing continuously?
So, Saryu, from a legal perspective, the police is supposed to file their charge sheet on any matter within 90 days of the notification being provided to the police. That's the theoretical view on it, but obviously practically that never happens. Unfortunately, the market precedence is that because there is no final report or charge sheet or recovery leads, we will adjust 25%, 30% as recovery has been compromised. Unfortunately, that came into effect much before I started my adjusting career, and it's quite unfortunate, but that's the reality of it. So as things stand, more so from a public sector point of view, the recovery, once evidence to have been compromised, which today the definition of compromised is inability to obtain a charge sheet or a final report, the market precedence is that you would adjust it and then provide your assessment.
In fact, I have seen few policies where the charge sheet is not required up to certain value. If FIR is there, then the insurers are settling claim. But that is with the private insurers. I have not seen that with the public sector.
And what about the cases wherein they've actually, from the FIR stage, gone to the court case? The culprits have been found, but the recoveries are not made. But the court cases, again, they go for years and years together. Is there any respite around that?
If the matter is in the court, I think then the police they filed their charge sheet in the court. So if the charge sheet has been filed, I think insurer can settle the claim. There is no need to wait till the final outcome of court case.
So we have a few more questions. One is from Mr. Paras.
We have opened up line for Radhika, so you can go ahead, please.
Yes, Radhika.
Hello everyone. For an ongoing claim assessment, which is currently going on in our company, the surveyors had asked us for an inventory audit verification report. When we supplied that, there was a minuscule percentage of shortage that was found. The audit report was a year old. Okay, and he had applied that shortage to the current claim assessment. When we said that the shortage has already been adjusted in our report, in our system, and the inventory that has been given for to the surveyor has already been adjusted with that shortage. Just wanted to know whether it's the correct method to do it, whether such a old shortage report be applicable even after a year.
You know what, I think I heard correctly. We are talking about that audit report of 1 year back.
Yeah.
Right. So I'm not aware of the exact facts of the case, But there is always, your shortage is not recorded unless you carry out a physical inventory.
Correct.
So there is a possibility of a normal shortage, which generally happens. I think surveyor must be talking about the shortage from the last audit till the date of loss.
Yes, that's what when we argued, that is what he told me. It might be possible. So my question is, in case of if my previous report would have given an excess, so would that percentage be also applicable?
The excesses are
This
generally
wouldn't be
because of
applicable,
the
no?
errors. Because of the errors, generally.
No, our systems are like that. We have a bulk upload system wherein inventory is bulk uploaded, and we don't actually scan our inventory and upload it in the system. So there might be a equal chances of shortage as well as excesses. So when we take a shortage, as a part of claim assessment, my question is, even in such cases, excesses should also be the part of it, since it's 50-50 chance in any inventory audit at any location, we can get a shortage as well as excesses.
Radhika, I believe this is very specific to your industry or your organization.
Yes.
So to sort of venture and give you an answer would not be appropriate in this context. But to take a step back and just to suggest or to recommend, I think the adjuster is well within their right to adjust for shortage if a one-year-old report suggests that a shortage is applicable in the inventory.
Okay.
If an excess is available, I would be akin to, it would in my opinion be akin to wrong entries or bulk entries or whatever else, but it would not add to the value of the claim, because that would not be an appropriate reflection of the inventory that would be at the site at the time of the incident. But having said that, I take a step back and say, if we do not know your particular industry or your particular entity, I think venturing into an answer would be inappropriate from this context.
Okay.
Thanks, Radhika. So we have next question from Dipali Wankede. If an asset is under warranty period and meanwhile any incidents happen, can loss assessor or insurer reduce the claim amount to the extent of warranty?
If the losses in warranty and the item which is affected in warranty and is affected due to the conditions which are within the warranty thing, then the OEM has to pay that particular item, and that will be deducted. But if the item has been damaged because of an incident which is out of the scope of warranty and for which OEM is not responsible, then that particular item will be forming part of the claim.
So next question is on ER policy, whether overhead charges are covered at the time of claim.
It depends on how the claim has been preferred. If the claim has been preferred directly on the cost, which has been all such costs which go into the item or the erection of that particular affected item has been already included, then overhead charges are not forming part of it. But if at all some generic items have been claimed and some generic items have been left out of the claimed items, and they also form part of the cost towards the erection of that particular item, they can be included. It depends how the claim has been preferred.
Then we have a question again from the same subject on ER policy, whether it compulsory requires reinstatement of damaged items. Whether a claim under ER policy compulsory requires a reinstatement of damaged items.
I would say yes to some extent, because it says that the policy says that the cost incurred for the reinstatement of the damage for the lost items. So the incurring of the cost will happen only after the reinstatement has been.
Also remember, the policy excludes abandonment. So if you've abandoned the project in its essence, then the policy would have a different interpretation towards the indemnity.
Niladri, Ganesan sir was raising hand. I think he's also, put in a question. If you can just put him on spotlight and unmute him. Ganesan sir. Yes, Ganesan sir.
Good evening, Somil. Good evening, Vivek.
Good evening,
Good
sir.
evening.
And I am seeing you after a very long years. Our two are youngsters. so no. Okay. My question is about, as I look, see, ensuing damage in the case of a particular machinery. Can you explain? Because in IAR,
ensuing damages in case of a machinery
in a
loss.
particular machinery,
right? What are you saying? Sorry,
see, some particular item is defective or deteriorated, is it because of the gradual workmanship or whatever it is.
Yeah.
And there is damage to the other parts of the machine.
So
because my question is relevant in the sense I don't have a definition of the term ensuing damage in the IAR policy. So when there is no specific definition in the policy, I have to go by what the dictionary says. Dictionary only says that ensuing means following damage, subsequent damage. That is what is in the Oxford Dictionary.
So ensuing damages are payable, sir, under the policy, as long as the ensuing damages are prevalent of the manner in which the policy reacts. So let's say there is just as an example, there is a machinery defect which is not covered under the policy, but there is thereafter a sudden and accidental damage to the ensuing parts or other parts, ancillary parts of the machinery. The ensuing damages that occur are payable under the policy at that instance.
I'll give you one more example here. Is like, suppose there's a gas turbine and the damages have happened in the compressor section, wherein a particular, it is proven beyond doubt that the compressor has been damaged because of some kind of material defect or some under warranty or some which is not payable under the policy. But the debris which is formed within the with this particular compressor section has gone into the turbine section and damaged that also, and turbine is damaged because of this flowing in debris. So that is an ensuing damage that would be covered under the policy.
In the newly introduced policy for SMBs, we do find a clause about indemnification. In case of stocks, it is talking about landed price, and so will be the case for indemnifying WIP. Now, do you think that this represents a clear indemnity, especially where the cost of recreating the product is much more?
Thomas sir, you'll answer.
Ganeshan is the one who would have turned down a lot of claims when he was in national earlier.
I have not turned down. No,
okay.
Somil.
No,
Somil,
Ganeshan, hold on.
Somil,
Hold on.
You may remember, it was I who suggested, I said, look, see, even a settlement of a BI claim without reinstatement being carried out. The name of the client is National Plastics and you are the surveyor. Okay.
Getting back to this, you were talking of the new policies, the Bharat Laghu Udyam, or is that the one you're talking about?
I'm not able to get the names because they are in Hindi. So that's why I said, policies introduced for SMEs.
No, I don't think there has been any change in the method of valuation. Personally speaking, I see a lot of defects in drafting of those policies. But I don't think there's any change in the method of loss assessment, except in the micro or the Graha policy where they say there is no underinsurance to be taken.
No, I'm not talking about Graha Ruksha. I'm talking about because here
stocks.
they have specified how the indemnity will operate. That is a problem.
But stocks, raw materials has always been landed price.
No, how can it be?
Whether defined or not.
Okay,
if the raw materials is the cost of purchasing and
no. I'll give an example.
Yes,
suppose I'm a trader.
Yeah.
I'll go on importing and I'll store it. I'm not importing for the purpose of public charity. I'm importing for the purpose of generating profit for my organization. See, maybe I'm storing this material for the last 6 months when the raw material price has gone up. And if you say that is it, I will pay only the landed cost, looking at the invoice price plus, bill of entry for duty, do you think that you are indemnifying me?
Ganesh, let me try to answer that question for you.
Manish, what we can do is we can take it offhand. We have few of the customers, there are questions which are pending.
Sure.
We can definitely have a separate discussion with
Okay,
Ganesh.
Shantanu, only one answer I would like to give. Somebody raised a question about institute replacement clause, and Avya Kapoor was talking about institute cargo clauses. The answer to that question is, they say institute replacement clause talks about payment of cost of repairs, including duty, when duty is included in the sum insured, which means to say it is applicable in the case of repair of a machinery, and there you will not get that markup of 10%. It is the actual repair cost which will be paid. It's for the benefit of somebody who raised this question on institute replacement clause.
Thank you, sir. Again, there are a few questions on the chat box. I'm just reading it through for the panel. This question is from Priyanka. Can policy excess amount under IR policy be reduced case specific? If yes, share your views. Yes, use and file wording is on. We may have few of underwriters talking about as long as there is a support from the treaty partner, GIC and others. There is a question from Amol Patil. Can it be possible to reopen closed claims after 8 to 9 years on the basis of received latest closure report? If yes, can we be eligible to claim reimburse standard deduction charges which deducted at the time of partial loss assessment? Question related to DNO fidelity claim, third party claim.
Amol, the answer to this would be that if you signed a discharge, which is a settlement agreement, and it caveats it as a final assessment or a final discharge, and not a preliminary or an interim discharge, I don't believe you have the capability of surpassing the limitation timeline of law, which is 3 years, and then reopening a claim after 8 years. Again, having said that, do remember within India, you can do anything, you can contest anything, but you will be faced, if it goes to a formal forum, you will be faced by these hindrances at that point in time, that you A, filed a discharge, and B, you are the jurisdiction does not apply, and C, the limitation period has exhausted itself.
The next question is from Pradeep. With respect to reinstatement, what happens in case of machinery is damaged and a replacement is not available? Will the claim be payable, whether the claim can be raised for BI, business interruption?
Short answer is yes.
Yes, you will be indemnified for the machinery, less the adjustment on account of technological upgradation or any other advancements. And your BI claim shall also be reviewed in the same manner. Do remember there are clauses within the environment now which allow you for the upgradation of machinery to be applicable for the indemnity.
Well, we have few more questions. This question from Mr. Puneet Panchal. How far the payment proofs required for loss assessment, which are essentially required by Surveyor? The basis of claim settlement requires cost to be incurred and not paid. The invoice itself is the proof of cost incurred. It is secondary how the invoice is discharged.
I would beg to differ out here, is because invoice might be charged, invoice might be raised, but the proof is required to be paid, whether you pay in through some kind of whatever the pending payments are to be there, credited are to be there. But the proof of payment in some or the other form is required for any kind of settlement of the claim.
In short, what we can say is the reinstatement means both physical as well as financial reinstatement. The financial reinstatement is completed once you make that payment.
I have a slightly different view here.
Yes, sir.
I would tend to agree that cost incurred You may not have a proof. I may have bought spares 10 years ago with the machinery that I've imported. Do I need to buy again to get the claim? No. The value of the spares that I've had, the value has increased over a period of time. I need to establish that this is the value, and issuing that spare from the store, I don't need to show proof of payment currently. What I've paid is good enough. And I think the indemnification should be based on current value. I don't need to buy it again. If I have 10 bearings in stock, I don't have to buy one bearing to show that I have incurred a cost.
Thank you, sir. I think we have a few more questions to be answered. Maybe we can, answer them separately. We've already exceeded time, and yes, it ought to be, because the engaging session and the enriching time which all of us had was amazing. We have a poll question. Maybe Niladri, if you can run the poll question before we wrap this panel discussion. Niladri?
I think, Santanu, the poll results are out. I think the response number 1 has the highest in terms of requirement, and it could just take it right.
Yes, and I think this reiterates the point which was all the panelists spoke about, that initial discussions is something which is very critical at the time of claim. Yes, we move on to the next poll question. What are the key areas of improvement in your claims management process? We have choice of identifying the incident, which would lead to claim reporting of incidents, survey management, understanding the requirements, document submission, licensing, all of above. Rightfully, all the above has got almost 73% of the vote. So thank you. We move on to the next poll question. Are our various team leaders trained on the practical aspects of claim? Yes or no? So roughly 67% answer is yes. We still have 33% yes, 33% as no. So with this, we come to our conclusion of the panel discussion. I'm sure there are a few questions which are unanswered. We'll take it offline. But my sincere gratitude to all the panel members. It's been an enriching session. Thoroughly enjoyed it, and I'm sure for all our participants, there are a lot of insights and takeaway from this session. Thank you all. Thank you for your time. Thank you.
Thank you very much for having us here, Shantanu. Thank you, Marsh, for doing this for all of us. And I thank my co-panelists for being able to bear with me as well. Thank you, sir.
Come on, Avia. Thank you.
Thank you.
Thank you.
Privileged to be part of this meeting and the discussion. Thank you so much.
Thank you, all four of you, for honoring my request. Thank you.
Thank you.